Hello, everyone. Eric Olsen from Helps. Sorry, a little late today, but we're here. My name's Eric, executive or founder of Helps. Helps is a national law firm that represents seniors and disabled persons who have debt they can't afford to pay. And we had a little problem getting started today, but we're gonna get going here in a second. Apologize for the delay. Okay, just got it here. So what I do is I take notes, and then you can put them in the chat feature too. If you got any questions, and I'll move over here. I apologize. I'm getting everything else straightened out. There we go. Okay, so I'm just going to start out since I'm a little bit late. Happy New Year. My husband and I, it says here, my husband and I have reached a point where we can no longer keep paying all our credit card and personal loan debt. I have been late. I've not been late on any payments for years and years, but now with ongoing health expenses and cost of living, our Social Security simply can't cover our monthly bills. We split expenses. When I finish paying my monthly expenses this month, I have $21 left. If we stop paying the debt, do we wait until things go to collection before contacting you? No, you don't need to wait. No, we get this. You don't need to wait. I tell people, so first off, what is HELP? HELP stands for Help Eliminate Legal Problems for Seniors. We're a national law firm that represents seniors who owe debt they can't afford to pay. We have two missions. One is to protect seniors from debt collector harassment. How do we do that? We do that under the Fair Debt Collection Practices Act. That law provides if you're represented by an attorney, debt collectors can no longer call or send you demand letters anymore. When people find out about HELPS, they call us on the phone, they enroll. They may call us 2 or 3 or 4 or 5 or 6 times before they decide to enroll. We don't turn anyone away. Cost is minimal. In some instances, it's free. Then you give us the creditors you don't want to pay anymore. We send them a cease and desist letter, and they're going to leave you alone. It's that simple. Now, if you get a new debt collection notice from a new debt collector, or if they sell it or assign it to someone else, get us that new debt collector, and we'll send a new cease and desist letter out to that new debt collector. The magic of HELPS is we represent you ongoing, not just one time. So sometimes people ask, like this person, if we stop paying the debt, do we wait until things go to collection before contacting you? No. If we have 5 people call us, maybe one's being sued, maybe 3 or 4 out of the 5 are being harassed by creditors, and 1 out of 5 is completely current on everything. It doesn't matter if you're current or not. You can contact HELPS. We can enroll you. We can send the cease and desist letters out. The creditors are going to leave you alone. You can be our client. And the nice thing about HELPS is when you enroll with HELPS, you're our client ongoing. It's not just then, but literally forever. So if you ever have a question down the road, or if you're concerned, please call us. Okay? So if you have any questions, put them in the chat feature. And there's a lot of people talk amongst themselves, which is fine. Yeah, Eric was late today. That's okay. I am doing it live today. There we go. So good to have you here. So this person calls us from Texas, okay, and it says they're concerned about a home foreclosure. They have collections, loan debt, credit card debt, medical debt caused by a medical condition in which I lost my job in August of 2024. Filed for Social Security disability in September. I didn't have any money for, they explained they didn't have any money for 9 months. It says Social Security disability has a 10 to 14 month waiting period due to employee shortages. Filed for early retirement in May 2025. I fell behind on my mortgage, leading to foreclosure. Had the house up for sale for 2 months. Auction date is set on January 6th. Oh my gosh. I'm sure we talked to him. If not, we'll need to. I've just sold my house with closing date set for February 3rd. How do I stop the foreclosure? You'd have to talk to us, but you might need to file a bankruptcy. You could file a type of bankruptcy called a Chapter 13 that would immediately stop the foreclosure and let the house sell. But I don't know when this person contacted us. They may have contacted us too late. I hope not. We don't file bankruptcy for people, but I probably filed 30 or 40,000 bankruptcies before I started help, so I know what to tell people. I'll go on. It says, what can I do about the collection credit card loan debt? You don't need to worry about them. They don't have to pay them. We're struggling financially like never before in our lifetime. I'm selling my pickup to pay off the remainder of the loan before it's repossessed. Truist has issued me a letter stating that January 6th is last day to pay off the loan. Collection companies are suing. I'm afraid we'll be living under. No, I'm sure you're going to be fine. They live in Texas. Depends on the type of foreclosure. Some types of foreclosure has a redemption period where you can get the property back over a period of, maybe 6 months or a year, sometimes longer, by paying the loan off, which would be from a sale of the home. But we'll talk to this person and go over it with them. But whenever there's a foreclosure, we want to know about it and talk to you, and we'll tell you, where to go, and you may need to see a local attorney. But not too many of our clients have that kind of issue come up. My mother is receiving Social Security of 126 and a government annuity my father left her when he died of 2250. She just got a judgment against her for property damage. I filed that she is judgment proof. You should win that. There's nothing to file. If they sue you and they, all a court wants to know if you owe money is if they should issue a judgment or not. And that depends if you owe the money. So if you owe the money, whether you're judgment approved or not, doesn't matter anything. Okay, the creditor can still get a judgment against you, but the question is, can they collect on the judgment? And if her income is from Social Security and an annuity, then should be protected. Annuities are a little bit different. In 46 years of practice, I've never saw anyone lose an annuity to a garnishment. Okay, although some states do limit the amount of annuity you can receive. Although I suspect with a federal annuity like that, it's going to be completely protected. You can always call and talk to us. Okay. Person calls and they say, I'm turning 66 in a few months. I want to retire at 67, but I have a large credit card debt with multiple credit cards. I'm currently working with a debt management agency to help me lower the interest and pay off these debts, but I will not be done by 67. Based on what I saw in your video, I would not need to pay these credit card debt once I turn 67 and retire, in the sense that they cannot garnish my Social Security. You could probably stop paying them now, but you're right. Okay. The only income that I have coming in at 67 would be the Social Security for my wife and myself. My wife does not have credit cards, so she does not get Social Security on her own, but she would get spousal Social Security. which would be half of what I receive. I also have a small 401k. It's protected. You don't need to worry about the 401k. If they can't garnish income, then it makes no sense for me to keep paying them once I retire out of Social Security, as I would not have enough money to live and pay my medicines. My wife and I have some serious medical conditions, which we take medicine for and have to go to a doctor regularly. I would like to know if I can call up the credit card companies right now and tell them I'm planning to stop paying them at 67 when I retire, and would they be interested in removing the interest rates and just letting me pay off the principal until I get to be 67? You could call them and ask them that. They're not going to say yes. If everyone could do that, everyone would be doing it. So they don't let you do that. Okay. Is that the route I should take? I'm an honest person who believes in paying debt, but I made a big mistake by putting a lot of my medical bills on my credit cards without knowing that I should not have done this. This has affected my credit rating, as I used to be over 800. Now I'm down around 600 or so. Please call me so we can discuss this. I also am interested in learning more about your organization. I want to make sure this applies to the state. Yeah, it applies to your state wherever you are. Also want to know if what it'll cost me. Well, so first off, he's going to be 66 and he's going to retire 67, so he's got another year to go. Okay. Now, if he stopped paying the credit cards now, what's the likelihood of him getting sued before he retires in a year from now? It's possible, not for sure. If he got sued, they could get a judgment. Got sued, it might take him normally 2 to 3 months before they could get a judgment at the soonest. Then, if they got a judgment, could they garnish his wages? Well, it depends on the state where you live. Okay, some states don't permit garnishments. Texas is an example. South Carolina, where this guy lives, doesn't. They couldn't garnish him there. And then every state protects a minimum of $217.50 net per week from garnishment. That's $435 every 2 weeks, $950 a month. Okay, but a lot of states protect a lot more than that. And like I said, some states don't even allow garnishment. So based on what he's telling me, he could probably stop paying the debt right now. He'd be okay. But it depends where he lives. Okay. We used the credit cards for a washer and dryer and did not realize how much the payments would be on our cards. Well, if you use the credit cards on the washer and dryer, they don't have a lien on the washer and dryer. If you stop paying the credit card debt, they couldn't take your washer and dryer. Okay. So this person called regarding being 100% VA disabled. He got served on December 31st, New Year's Eve, for a debt that was several years old. And he has 20 days to respond. Never talked to us before. He received Social Security benefits. Yeah, so we're going to call this guy back if we haven't already. We're going to tell him, your Social Security is protected. No one can take it. If you owe the money, you don't need to respond to the lawsuit. They can eventually get a judgment. I mean, if you want to respond to the lawsuit, if you don't owe the money, you want to contest it, that's up to you. We don't help people do that. Most of our clients have no need to do that because, like this guy, his only income is Social Security. It's protected. They can get a judgment. They can't collect from him. He doesn't need to worry. So, question, Eric, my neighbor is here, and she asked me about an item on her credit report, National Card Adjustment. She defaulted on a loan. I told her to come over to watch. Is there anything that she can do? Well, okay. First off, let me talk about credit for a second. I've been an attorney now for 46 years and started helps in 2012. And for almost 10 years after starting helps, I tell seniors a lot, and the vast majority of seniors even today, they're not worried about credit. Um, they don't really care. Or if someone enrolls in helps, if they have a credit card that's good, smaller balance, if they want to keep it, they can keep making that credit card, keep making that payment, and keep that credit card as long as it's not backed by a bank with whom they have another credit card they're not going to pay. So they can keep that credit. But sometimes seniors want to restore their credit. And so we have a program set up with 720 credit score called 720 Credit Score for Seniors. It's free to our clients that have been part of helps for 90 days. And what happens is you can enroll in this program. It's free. It doesn't cost anything. And you actually can rebuild your credit. Believe it or not, your credit is based on your recent credit history. So even if you have negative entries on your credit, once that debt gets written off as a bad debt, you can start to rebuild your credit. Okay? And your credit is based on like I said, your recent credit history. In about 2018 or 2019, the credit bureaus stopped reporting lawsuits and judgments on credit reports. So even if someone sued you and got a judgment, it's on your credit report, it's not going to be on your credit report. Okay? They stopped putting it on credit reports because they were getting sued. The credit bureaus were getting sued because some guy would be buying a home and he'd paid off a debt, and then that judgment might show up as a lien, and it would delay him getting his loan, and he'd sue the credit bureau for not reporting correct information. So now the credit bureaus only report what people tell them. They don't report judgments or lawsuits because they'd have to monitor the court very carefully. And if the court made a mistake and didn't remove the judgment, or they made a mistake, then they were getting sued, and they don't want that to happen. So they don't report lawsuits or judgments on credit reports anymore. Now, normally the one who reports on your credit is the creditor itself. Okay, but sometimes it can be a debt collector, which looks like in this case. We don't give people advice on how to restore their credit. That's not what we do. But what we do is, if they're a member of helps, we provide this program for them through 720 Credit Score, where they can rebuild their credit on their own. Okay? So Nancy asks, I bought a car and was unable to pay for it in 2017. They put a lien on my home. Can they take my home? Well, the only way they would have put a lien on your home is if you bought a car back in 2017, you didn't make the payment, the car got foreclosed or got repossessed. And then the lender sued you for the balance that you owed, which is called a deficiency. And then the deficiency could become a judgment, and a judgment theoretically can become a lien on the home, normally in the county where the judgment is located. Now, that's not everywhere. For example, in California, your home would have to be worth well over $700,000 before it'd be a judgment would be a lien. And then in some states, if someone gets a judgment, it could be a lien, and there's a procedure for getting the lien removed. Florida, for example, Texas, for example, there's procedures for that. In other states, it could become a lien. It could be removed by filing a bankruptcy. And then the other factors are maybe you own a home as a husband and wife, and the judgment's only against the husband. If the husband predeceases the wife, then the property goes to the wife. That judgment lien disappears. The question you have is, can they take my home? It's not the practice of consumer judgment creditors to go after people's homes. They don't do it. Now, is it theoretically possible? In certain situations it is, but we just don't see it happening. I almost want to say ever. Okay? So you're asking, can she get that negative entry off her credit report? I'm not sure how she would do that. It's not what we do. I mean, if she's a member of HELPS, she can enroll in that program. Um, but we'll help her with her credit. What should I do now that lawyers want to continue on with this? So, yeah, so let's say if someone enrolls and helps, we're going to send a letter to your creditors you owe money to, a cease and desist letter. They can't bother you. Does that mean they're not going to sue you? No, they could sue you. It's not uncommon. You could be sued. Um, does it guarantee you're going to be sued? No, no, but you could be sued. But when a helps client is sued, what we do is you get us a copy of the lawsuit. Usually we need just the first 3 or 4 pages. Then we're going to send a letter to the attorney who sued you, letting him know that your income is protected, that you can't afford to pay the debt. We're going to call you on the phone, explain why you don't need to go to court. We'll send you emails with links to videos and articles on why you're going to be okay. So, no, you're not going to need to go to court. You're not going to need to worry. If they get a judgment, you're going to, we're going to explain how your income is protected, twice the amount of your Social Security deposit into your bank is protected automatically from garnishment, regardless of what other funds are in there or where they come from. Okay? So this guy calls, he says, it's a message. It says they called regarding a debt matter. He mentioned that his deceased wife left a credit card debt that has caused a lien on the property he co-owned with her. He would like to know what legal actions he may take. He didn't mention having previously spoken. Okay, so if you're married, this is what I just talked about. If you're married, and in this case, the wife had a debt against her, it was a credit card debt, and it sounds like she was sued. So if they sued and it was her debt, they would have just normally just sued her, not him. So there would be a judgment against her. Now, normally when a husband and wife own property, they own it as joint tenants with rights of survivorship. That means that she owned it with her husband together. And it means that when she passed away, the property automatically went to the husband. Her name is no longer on the property. She may still have her name on the mortgage. That doesn't matter. She's dead. The property is now in the husband's name alone. So the judgment lien, when she died, the judgment lien disappeared the moment she died because at that moment the property transferred to the husband, and it's his name alone. And it'd be vice versa if the debt was owed by the husband and the wife was the one that survived. So he's not gonna. This guy isn't gonna need to worry about that debt that his wife owes. Not gonna need to worry about it. Okay, this guy calls us from Texas and he says, I received a letter saying that I will be sued for a debt I defaulted on. I'll be responsible for paying court costs and fines and a judgment. I cannot afford paying it. I cannot afford to file bankruptcy. I just watched a video on YouTube and decided to reach out to you. Yeah, well, yeah, if that's you or someone, if you're having the same type of problem, remember, if you're getting Social Security, a pension, disability, 401k, IRA, virtually any form of retirement, that money is protected under federal and state laws. It can't be taken from you. You live in Texas. Texas is going to protect any equity you have in your home. They have a $50,000 exemption over all your other property. You're not going to lose anything. Okay. You don't need to worry about. Now, that doesn't prevent a creditor in Texas from still suing you. They still do that. You see, these creditors, they count on you not understanding the law. They kind of figure, this person isn't going to know the law. We're going to sue them, get a judgment. We want to get them to call us on the phone and make arrangements to make payments. They have no obligation to tell you what your rights are. Okay? Are we obligated to divulge bank account numbers to a lawyer doing discovery in the debt lawsuit? Well, kind of yes and no. I guess, you know, based on what I'm telling you, if someone sued you and got a judgment, you understand that twice the amount of your federal benefit, like your Social Security, that goes in your bank account is automatically protected. Even if they garnish your bank account, your bank's going to protect that. I don't know why they want your account number, because all a bank needs to know is where you bank to try to garnish you. Okay. I remember when I was a young attorney years ago, when I was in law school, I used to do collections for my old law firm, commercial collections. And if we got a judgment against someone, we were able to call the bank and we'd ask, will a check for this amount clear? And the bank would say yes or no. Well, the bank would never tell you that now. And you know, a creditor gets a judgment against you, they don't need your account number to try to garnish you. That's meaningless. If they had your account number, could they call and try to get money out of it? Not legally. The bank's not going to tell how much money you have in there, so it doesn't matter if you gave it to them or not. I would tell most people that, you know, don't need to worry about giving them your account number. I'll give you another example. So Florida has what's called a fact information sheet. If they get a judgment for you against Florida, then they're automatically going to send you a form, almost always called a fact information sheet. It's like 2 or 3 pages with maybe 15, 20 questions that ask the craziest things on earth. They want your kids' names and addresses. I mean, if I got one of those, I would never give my kids' names and addresses. Who's to say that I even know their address, where they're living? And what is it? What does it matter? But some person originally with this form came up with this form. The courts adopted it. They said you can use this form. It's used by the attorney who sues you and gets a judgment. And I think when people get this form and they ask certain questions about your assets and your kids, and it gets people all scared, nervous, and so they call the attorney to arrange to make payments when they don't need to. Now, if you've got a question on any of this stuff, you give us a call. The number's down here. Where is it? Down there. And we'll go over your situation. We don't want you to worry, because you're going to be fine. My husband and I are both on Social Security. I'm 67. He's 69. We were sued for a loan of $1.5 million. Have $100,000 credit card debt, paying minimum interest only. Live with kids. What can we do? Oh, that's a great question. You don't need to pay the debt, and you don't need to worry. Your only income is Social Security, Cindy. It's protected. If you have one bank account with your husband, the amount that you get together, twice the amount you get each month, is protected from garnishment automatically by the bank. If you happen to have more than that in there at a garnishment, then you can file a claim of exemption or challenge the garnishment, and the court would order the excess be released to you. But if you got $1,500, if each of you got $1,500 in Social Security, $3,000, $6,000 in the bank account is protected. I don't care if you have a judgment for $1.5 million or $50 million. It's protected. I don't care if you have credit card debt of $100,000 or $200,000. It's protected. You don't need to worry about it. Okay? And if you don't want to be bothered by the creditors, then call helps. We'll explain what we do. If you want, you can enroll in helps. You can be enrolled over the phone virtually immediately. We click a button, we keep you on the phone, you're going to get an email that says, welcome to helps. I already did that earlier this morning with someone. And we're doing it all day long. And that email confirms you're a member of our program. It gives you all our contact information, tells you how to get us the creditors you owe money to. And then we're going to send them a cease and desist letter. We don't need the how much you owe. We just need the name and address of the creditor and the account number. It's that simple. Yeah, Turbo's right. The bank, you don't need to talk to the bank. I have yet talked to a bank manager that knows this rule about how twice the amount of your Social Security is protected automatically. And there's very, very few attorneys that know this rule. It's been in effect since 2012, but the word really hasn't got out because a lot of attorneys don't practice in this area. So, but there's a department in the bank that deals with garnishments. They know the rule. And then when they get a writ of garnishment, they know to look at your bank account. They usually do that within a few minutes, and they can see if federal benefits came into that. And you're right, there's a code on your deposit that lets them know. Now, what's a federal federal benefit? It's Social Security, which is the most common one, be a VA benefit, United States Post Office retirement, railroad retirement, or a federal worker retirement. That's all federal benefit. Okay? So federal, VA disability income, all of this. Yeah. Person contacts us from Minnesota. I'm in debt with credit cards and 2 loans. Please help me get through this. I'm 84 years old and would like to have peace and happiness during my remaining years. I want you to have peace and happiness during your remaining years too. And I hope there's a lot of them left in front of you. That's why HELPS was started. I've been in practice since 1978. I did all kinds of law, and then in 1986, I was doing bankruptcy almost from the beginning. 1986, I saw the writing on the wall. There was too many people having financial problems, and they weren't getting good help. And so I concentrated on filing bankruptcy, and that's all I did. Formed a very large bankruptcy firm that's still in existence. My brother is the senior partner, and they file a lot of bankruptcies. But a lot of seniors would come into me when we were doing bankruptcies, and I tell them, I say, well, you don't need to file bankruptcy because your income's protected. And a lot of them couldn't afford to file bankruptcy. But I knew if they didn't file bankruptcy, creditors are going to call them on the phone and make their lives miserable. And bankruptcy at one point wasn't all that expensive, but then in 2004, the bankruptcy laws changed. And they introduced what's called a means test, which was a test that said if you make over a certain amount of money, then you can't file bankruptcy. You have to file a different type of bankruptcy. And then you have to get education before and after you file bankruptcy. So it immediately made bankruptcy more complicated and at least doubled the cost. And I remember back in 2004 when this law went into effect, it changed everything. I mean, the cost of bankruptcy went really high. I don't want to be political or anything, but the guy that behind this law change was Biden. He was getting a lot of political contributions from the banks, and I'm not giving my political affiliation. I'm just saying what is the fact. And he worked on that law for almost 10 years to get it passed, and finally in 2004 it got passed. And I remember before it went into effect, I don't know if it went into effect on January 1st or whatever it was. I can't remember. But I remember we filed like 500 cases, like in a couple of days just before. A ton of cases got filed. And I remember when the law passed, I told my partners, I said, this law, what they want to do is they want to decrease the filings of bankruptcy. I said, that's great, but it's almost trying to legislate to someone that they can't have a heart attack if they got health problems. You can't legislate, you can't have a heart attack. Legislation isn't going to do it. And that's the same thing with this new bankruptcy law. it never slowed down the filing of the bankruptcy. It was too easy to get around it or be able to solve the problem. So bankruptcies started being filed again. And then what happened in 2008, 4 years later, the Great Recession hit. Now, when the Great Recession hit, you remember that? All of a sudden, the money dried up. A lot of people lost their jobs, and it was really hard on seniors. A lot of them couldn't afford their homes. There was tons of foreclosures, which led to a lot of bankruptcies being filed. And then there was still a lot of problems. And then seniors were still having problems. I was doing a ton of bankruptcies back then. I was the head of the firm. And finally, I came up with this idea that, seniors who owe debt that couldn't afford to file bankruptcy didn't need to file bankruptcy. There had to be another way to help them. And that's where HELPS comes in. Help eliminate legal problems for seniors. What we do is we represent you under the Fair Debt Collection Practices Act. That law was passed the year I graduated from law school, 1978. And one of the provisions of the law says if you're represented by an attorney, debt collectors have to call the attorney, not you. And I said, well, why can't we do that? Can't we represent these seniors that are lower income or poor, and we'll represent, if they don't need our help for free, we'll give it to them for free. So for about the next 4 years, when I was still with my old law firm, I started HELPS. And my firm backed me up on this. I spent probably half my time with HELPS. And then finally in 2016, I saw the writing on the wall, and I told my old law partners, I said, I've got to leave the firm and just do HELPS full time. It's too busy, and there's too many people need our help. And so HELPS has been around since 2012, and will be here forever. When I'm long gone, HELPS will be here. So our mission is to protect you from collector harassment. Our second mission is to educate seniors how they can maintain their financial independence. And that's why we have these YouTube videos, so that you can learn other things. You can call and talk to us or ask questions, okay? And we always like when people spread the word. A lot of people need this help. I hear too many times, I wish I'd known about this sooner. So this 84-year-old guy from good old Minnesota, we've got enough problems in Minnesota as it is, let alone these debt problems. He says, I'm 84 years old and would like to have peace and happiness during my remaining years. That's the nice thing about HELPS too, is when you enroll in HELPS, it's not a one-time thing. You're a client literally for the rest of your life. So if you incur a new debt, if you have a new debt collector contact you, you let us know. We send them a letter. They're going to leave you alone. If you ever have a question or concern or worry, you pick up the phone and you call, no matter how often. Okay. So this guy contacts us and he says, hello, good morning. My name is, my wife and I live alone. We're seniors and both of us are disabled. And so I'm one of these, I have 3 accounts and I don't know why or what it's for. All we have is, we're very poor, and what we have is my Social Security. My wife never worked long enough to get any special security. Please help us. It just occurred yesterday that I can't. I'm afraid to reach out. Apparently got a letter or something. Maybe he's been sued. I'm afraid to reach out to the lawyer because I'm here the wrong, I might say the wrong thing. Whoever this collector that my credit union gave me the number. So apparently someone at his credit union gave him our number. We're getting known more and more. Someday HELPS will be a household word. We're the only law firm that does what we do, and it should be a household word for seniors that are struggling, that have debt, that are on Social Security or pensions, who can't afford to pay their debt. So we're going to call this person back. Only income is Social Security. We're going to tell him he doesn't need to worry about the old debt. If he's been sued, he's not going to have to go to court. They're not going to be able to take his assets. He can enroll in helps. We're going to contact them so that they don't bother him anymore. He can always call us with his questions. That's what we do. So if you're that person or in that situation, call us. That's what we're here for. You'll be glad you did. We don't turn anyone away. Here's another one that called us, and I tried calling this person back today again. It says, I'm very sorry that I missed your phone call yesterday. This is a note from last week. Being so depressed, I too often nap and miss out on much. My health has been declining now because of the severe unrelenting strain. However, missing your call yesterday has given me the opportunity to list at least some of my questions that I have for you, Mr. Olsen. Please keep in mind that I no longer have the ability to think clearly because of the worry. So this list may be a very short one. And then here's the questions. And if this applies to you, so be it. Because we are painfully, absolutely overwhelmed with indebtedness, would we be subject to letters and calls by the original creditor, such as Discover? So the Fair Debt Collection Practices Act technically applies to debt collectors, not original creditors, but 7 states apply it to original creditors. But let me tell you my experience. First, Discover's kind of been bought out by Capital One. Discover's going by the wayside. But be that as it may. Yeah, when you enroll with helps, you're going to give us the creditors to whom you owe money, debt collectors, and we're going to send letters to the debt collectors and the creditors. And it's our experience that the creditors are going to stop calling you as well. And if they were ever to reach to you, you would tell them you're represented by helps, give them their name and number, and hang up the phone. Because when we talk to you, we're going to tell you why you don't need to worry, that they can't do anything. You're going to be okay. Okay? So next question. My husband said that notification of our bad credit will be revealed by at least some agencies or reviewed. Does it matter? Should my husband refuse the opportunity of being rid of this suffering by signing on with you? Can I be relieved of indebtedness on cards with both our... Yeah. Well, you're going to call and talk to us. When people call us, we have a list of questions. They're on the computer. We call you a PC, potential client. And we're going to ask you like your name, where you live, are you married, your phone number so we can call you back if we need to, how you found out about us, what's your source of income, are you buying a home or renting, how much you owe on a home, how much it's worth. We need to know those kind of things. Are you buying a car? Do you own a car? What are you paying rent? Has anyone sued you? Do they have a judgment? Do you owe any taxes, student loans? And then we're going to read you and then how much you owe in credit card debt and unsecured debt, approximately, just a range. We don't need the exact amount. And then we'll read you what we do, how we protect you. And if you've been sued, we're going to talk about the lawsuit. And then we're going to explain how your income is protected, why you don't need to worry about the debt, talk to you about what the fees are for helps. And it's minimal. Most a person would pay would be $40 for 24 months, $20 for 24 months, free thereafter. It could be $30 for 24 months, $15 for 24 months, free thereafter, or $20 for 24 months, $10 for 24 months, free thereafter. It depends on your household income. And then we save this information. You can enroll then if you want. We do it right over the phone. You can call back later. When you decide to enroll, all we're going to need is your address, the month you were born, last 4 digits of your social security number. We need that because sometimes a creditor will call us and confirm that we represent you, and they want to know what the last 4 digits of your social security number. That knows that you've communicated with us. And so then we're going to click a button when you enroll, and we're going to keep you on the phone. You're going to get an email from Helps that says, "Welcome to Helps." We tell you how to get us the creditors. All we need is the name, address, and account number, balance you owe. You text it, fax it, email, or mail it to us. whatever is easier. The person goes on, they say, I can't go on further with letting you know of the questions now, but perhaps I will be able to expand this list later today. I will try at various times throughout the day to phone you. So you don't need to speak with me. I'm not always available. Okay? We've got other attorneys that helps and very experienced paralegals that's going to be able to answer your questions. Okay? I must find a time when my husband can't overhear. It's much too cold here to go outside to speak. Okay. Yeah, we're happy to talk to you and explain to you how to share it with your spouse. Don't have to, but you can. I'm sensitive to this issue. I'm sensitive to a lot of these issues because I've been doing this for 46 years. I told this story one time, and I tell these stories periodically, but a lot of you probably haven't heard them. It had to have been, could have been 30 years ago. I got a call from a guy, and after a few minutes talking, I realized that he didn't have the faintest idea that he had filed a bankruptcy, and I think it was a Chapter 13. And I kept thinking to myself, how in the world did he get this far, not knowing that he'd been in a bankruptcy? And then I figured, his wife's been hiding it from him. And then apparently he had never even gone to court, but the trustee let it go through with just the wife. And he was in a total state of shock. When I talked to him, I said, you know who you're talking to? He said, no. And he said, well, my name's Eric. You filed bankruptcy. You realize that? And he said, no, I didn't. And then I looked at the file and I told him, I said, listen, I'm going to talk to you for a few minutes. I don't want you to be upset at your wife. I said, in fact, you should be thankful for her. She saved your goose. She was probably scared or intimidated of you. And that's why she didn't tell you this. He didn't say anything. I said, you better be nice to her because I'm going to tell you what she did to save you. And then I went on in detail and explained to him why he was going to be okay and why what she did saved everything. And I explained to her the problem she incurred this debt because she was trying to keep things, you turned it all over to her. There wasn't enough money to pay it. It wasn't her fault. And at the end, I'm pretty sure I got him to buy into what I was telling him because I was telling him the truth. And I have a way of explaining things that I think can convince him, are convincing. And I don't remember the rest of it, but it was okay. Now, I never followed up with the court or anything to say that this guy actually had filed a bankruptcy. He didn't even know what he was doing or didn't even know he was part of it. He had to forge his signature and a lot of things. But I let a sleeping dog lay because she'd really solved the household problem. So when this lady says, must find a time when my husband can't overhear, we're glad to talk to either a husband or wife about their situation. So we're understanding that way. Okay. So this person asked, and it's a fairly not that common of a question, but it does come up. Oh, it's 1 o'clock, my time. But I started 5 minutes late, so I'm going to go for another 5 minutes. Okay? Just with this one question, this last question. He says, may I ask is life insurance protected in Texas? My husband passed away due to illiterate doctors who examined him twice a year and didn't see that he had cancer. More of that, they complimented his health. Then after 3 months of such examination by his cardiologist in prime care, he just lost his consciousness and passed away in 2 months. Being diagnosed in a hospital with cancer stage 4. Now, in addition to all this horror, I'm facing to pay his credit card debt, medical bills from the hospital. You live in Texas, you're not going to need to pay it. They can't come after your Social Security or retirement funds. I'm a senior on Social Security, no pension. You don't need to worry about that debt. I would appreciate any opinions. And they want to know about the life insurance. He died, he had life insurance. The life insurance is protected in Texas for the beneficiary. It's Texas has strong laws that protect life insurance. It's dependent on state laws, but almost every state protects life insurance. I'd go over it with people. Okay. So I apologize for the late start today. If you have any questions, call us on the phone. We're here to answer them. Some people call us 2, 3, 4, 5, 6 times, even more before they decide to enroll. We don't help. Helps sometimes over a year or longer, or years. Finally, they realize they need our help. So if you have any questions, call us. And tomorrow I'll be back with you same time. I promise to be on time tomorrow. God bless and have a great day.